We would like to invite all of our delegates to make their way back into the hall. The program is about to resume. To all of our delegates who are still getting their coffee, we would like to invite you back into the hall and take your seats. The program will resume shortly. Thank you. Once again, we would like to invite all of the delegates to return to their seats, please. Once again, to all delegates, please return to your seats. The program is about to begin. Thank you very much. Calling on all delegates, please come back to the hall and take your seats. The program is about to begin. Once again, to all of our delegates, if you're still in the foyer, please come back to the hall and take your seats. The program is about to begin. Thank you. Once again, good morning. I'm back. May we invite everyone to please take their seats. If you're still outside and hearing us, please come back. The program has now resumed. Okay, couple of reminders to the delegates who signed up for cultural tours. We hope you got the chance to pick up your t-shirts. If you want to sign up for cultural tours, please proceed to the registration area. Now, after this plenary session, you will be heading towards your breakout sessions. Please check your belongings. Make sure you don't leave anything behind. I'd like to remind everyone this early not to leave anything behind, especially your personal items. Now, with that said, allow me to introduce you to the next plenary, and it is the Cartel Working Group Plenary entitled Algorithmic Collusion and Challenges for Cartel Enforcement in the Digital Era. Leading the discussion, we have our moderator from the Commerce Commission of New Zealand, Mr. John Small. Good morning, John. Come on up and join me. As I introduce our distinguished speakers from across the globe for this panel, we have from the Competition and Consumer Commission of Singapore, Mr. Alvin Kaur. From the Competition Commission of India, Ms. Ravneet Kaur. Comisión Nacional Antimonopolio Mexico's Mr. Victor Meyer. From the Administrative Council of the Economic Defense of Brazil, Mr. Diogo Thompson. And from the Federal Cartel Office of Germany, Dr. Doris Hildebrand. Good morning to our panelists. Please take your seats. And Mr. Small, the floor is yours.
Welcome everyone to this plenary session in the Cartels Working Group, focused on high-tech subject of algorithmic collusion and challenges for cartel enforcement in the digital era. Speaking with our panelists earlier, we've discussed the fact that obviously there are a lot of challenges. We've got some very interesting material about to be discussed, but there's also a few opportunities for agencies to use some of these tools, and so some of that will come out as well in this session. Obviously, these are topics that we're all grappling with as the nature of digital business just keeps evolving and changing rapidly. So we're really pleased to have here today a group of people who really can contribute in a serious way to help us understand these matters. So let me just introduce our panelists. I'll start with Alvin Koh, who will be known to many of you. Alvin is the Chief Executive of the CCS, the Competition and Consumer Commission of Singapore, which is the main enforcer of competition and consumer protection in Singapore. Alvin's got extensive experience in the public sector, including serving as the Chief Legal Officer at ministries like the Ministry of Finance and Manpower, and as Deputy Public Prosecutor specialising in white-collar crime. He was also a judge in the Singapore State Courts, and he's currently sitting on the Ministry of Law's Copyright Tribunal and has an academic role through a Leon Fellowship at Nanyang Technological University. So welcome, Alvin. We're looking forward to what you've got to say. We have, sitting next to Alvin, we have Ravneet Kaur, who is from the Competition Commission of India, and she's been the chairperson of that commission since May 23. And in that role, she's provided leadership and guidance for operationalising the relatively new Competition Amendment Act, which was also passed in 2023 in India. Ravneet has got a rich and varied experience of working with the government of India and the government of Punjab for over 30 years in various capacities. Her professional experience relates to finance, industry, accounting, and budgetary matters. She's got experience in corporate affairs, management, business operations, and leadership as chairperson and senior executive. So welcome, Ravneet. We're really looking forward to what you've got to say for us. Sitting next to Ravneet is Victor Meyer. Victor has served as the General Director of Cartel Investigations at Mexico's Competition Authority since 2023. He first joined the Commission in 2011 as an investigator, and throughout his career he's participated in and led complex cartel investigations across a wide range of markets. Victor he's a lawyer, law degree, and LLM from UCLA. Next to Victor is Diogo Thompson. Diogo has been acting president of the Brazilian Competition Authority, Cartel, since April 2026, and has been a commissioner there since 2023. Previously assistant superintendent at Cartel for 11 years, as well as acting superintendent general on a couple of occasions. Diogo's got a PhD in law from Brasilia Institute for Education, Development and Research, a master's degree in the philosophy of law from the Pontifical Catholic University of Sao Paulo, and he's been a federal attorney since 2004. And last but not least, on my immediate left is Professor Dr. Doris Hildenbrand, who is a consulting economist, so one of the specialists in this area, very pleased to have, a managing partner of EE and MC, which is based in Munich, Paris and Vienna, and that company specialises in application of sophisticated economic analysis to competition law. Doris has worked on projects of more than 200 clients in various industries, and she's also a court-sworn and certified expert for competition economics at the Competition Court in Vienna, and in that capacity she informs me that she's able to be hired by either the court or by one of the parties to a matter, but it's a special screening status that she holds. So welcome to all you fine panellists, and we're really looking forward to what you've got to say. And just a little bit of a brief word from New Zealand. We've obviously been working in this area in cartels for a while. We're trying to be developing our own expertise and understanding whether there are issues arising from algorithmic collusion, and building up our own capacity to analyse information that comes from cartel investigations using some of these tools. So I think with that we'll crack into it. The format for the session is that each panellist will speak for 10 to 12 minutes, and a couple of people have slides, others don't. We'll listen to what they've got to say, and then we'll have some question and answers at the end. And so I believe the speaking order is that we're going to start with Victor Meyer. So Victor, can I ask you to address the crowd?
Thank you so much, John. So first and foremost, it's truly an honor to be here sharing this panel with my fellow colleagues. So it's up to me a little bit to talk and introduce the topic of algorithmic collusion. I'm sure that many of the things that I'm saying you've heard all over again, but it's still an issue. I'm going to talk certainly from the perspective of Mexico and how we're handling and seeing this problem. So I think that when you talk about algorithmic collusion, you have to, I would like to talk about two aspects that are problematic. The first one is from the legal perspective, and the second one is related, but that's the evidentiary standard. So the way I see it, and the way that we've been seeing it in Mexico, is that we have at least, there's two issues, or big issues, or situations, or hypos, sort of say, that will deal with algorithmic collusion. The first of them is, I think, and this is more common nowadays, is having these platforms. These platforms where competitors share their information, and the platform, the competitors hire this platform to get either guidance or perhaps some recommendations on pricing, output, where to invest, when to invest. But they're providing, in order for these platforms to work, competitors are providing these platforms very, very specific, confidential, and strategic information, dealing with pricing, dealing with how their strategic business decisions, where they plan to invest, their output, and so on and so forth. And these platforms are generating, through the use of algorithms and AI, very specialized and very personalized recommendations. And at first glance, that's good. They're using tools. It's just we wouldn't be concerned, for example, with them using a spreadsheet. But the problem here is that these platforms are offering their services to multiple competitors. And all of these competitors are providing their strategic and confidential information to these platforms. And so this platform is certainly not going to be favoring one of them and affecting the other. So what is left there? It's that they're coming up, and we're seeing this in several markets in Mexico, where when they introduce these platforms, we're seeing a collusive outcome in terms of pricing. Prices are rising, which should not be happening because they're competing. What's the issue here? Yes, they're using algorithms. Yes, they're providing their information. How do you prove the meeting of the minds? There's no communications between themselves. They're simply talking with the platform. You could argue, and go for a hub and spoke, but is there really, some sort of communication even through the platform? We're talking more about tacit collusion here, where you would have to argue they're providing their data, their sensitive information, and they know that their competitors are doing the same. And they know that this platform is going to give them their best, the best outcome to each and every one of them. It's simply not reasonable that if you're hiring a platform, it's going to affect you and benefit your competitors. There's simply no reason for that. So that's where you build the sort of like tacit collusion. But that becomes a little bit more difficult in terms of proving it, and the evidentiary standard is certainly difficult. Our jurisdiction in Mexico is more administrative, on the administrative side. We also prosecute cartels criminally, but that's done after we carry out our investigation from the administrative side. So we don't have to deal with the criminal standard that I know some other jurisdictions have had to deal with that. But still, it's still very difficult, as I think everyone in this audience knows, to prove tacit collusion.
Victor, could you just a little closer to the mic?
Oh, of course, yeah, so sorry. It's very difficult to prove tacit collusion. So that's one of the issues, one of the hypos. The second hypo, I think, which is even more concerning, is when algorithms start to communicate between themselves, and thus you have collusion without human interaction, where there's two machines talking to each other and finding that the most reasonable outcome is to exchange information and come up with a fixed price. Once again, and here it's more difficult, is how do you deal with that? How do you prove the meeting of the minds that's the central element of cartels? The agreement part. How do you do it if there is no human interactions? If perhaps even the companies that design these algorithms, which might not be even participating in the market, they are software providers. They have no idea what they're doing. Or even the companies that are using the algorithms to fix their prices internally, they have no idea that their algorithms are colluding. It's this lack of human interaction. What have we done so far in Mexico? Well, I think that there's two changes or two things that we've been working on that will allow us to face this problem in, I don't know if the result's going to be efficient or not, but it's certainly some things that we're trying to do for that. The first of them I want to talk is a recent case that in which we just filed our statement of probable liability. So I do have to make a disclaimer here. This case has not been reviewed by our Board of Commissioners nor by the courts, but it's something that within the investigative authority we're pushing for, and hopefully it will set an interesting precedent that we can use for algorithmic collusion. So what happened in this case? We're talking, a classic case of collusion between two competitors that are fixing prices. That's regular, as always. But what changed here is that they're using a platform to supervise and monitor themselves. And with this platform, they've been providing very up-to-date, very confidential information regarding their pricing, regarding their output. It's extremely sensitive data that they provide in real time. And thus, they can check that they're actually following the prices that they're doing. The thing is that this platform, there was no evidence, and if you ask me personally, my personal opinion, this platform was not aware of what these two competitors were doing. They were just using their product. But still, it allowed them in some sort of way to collude and to monitor each other. What we did was we changed the standard here because we actually filed a statement of probable liability against this company, this platform, even though it wasn't even aware that these competitors were using its platform to collude. Why did we do this? We did this under a sort of like a new standard, more so like negligence instead of intention, where we argued like you're providing this product, you're charging the competitors and companies for acquiring this product. And you're allowing them to see information from each other, and it's extremely sensitive information in real time. What do you think is going to happen there? You should have taken a duty of care to prevent collusion in this aspect. So what we're doing is that we're not longer prosecuting from intention, we're migrating to a standard of care, more akin to negligence. So I think that this case will certainly we'll be able to use this case for algorithms where it's not just necessarily like, yes, you're building an algorithm, but you have to be responsible for what this algorithm is doing, either because you bought it and you're using it or because you designed it. So you're responsible for what you're doing it. And this is something akin that was happening with artificial intelligence, for example, with self-driving cars, where there is a strict liability clause. So it would be, obviously this would need a legal change, but we could even argue strict liability for this. The second change that we have, it's actually a legal change that we just underwent. As some of you might know, our authority in Mexico underwent massive institutional and legal changes. And these legal changes were made to strengthen the fight against cartels. And amongst these changes, what we had was that now it's we no longer need to prove an agreement per se, just a mere information exchange can be enough. I know that this is something that's common in various jurisdictions. We didn't used to have this, but nowadays with this recent legal change in which we just have to prove the exchange of information, not necessarily the meeting of the minds, that actually will help us as well to face, I think, algorithmic collusion in a way. So just to summarize what I've been saying, I think that what we're trying to do is to change a little bit the way that we look. If we keep on looking for intention, it's never going to work out because we're not going to be able to find either direct communications as we used to do in the past. We're going to be facing with some issues that will be tacit collusion and an evidentiary standard. It's very, very difficult to prove. So the way we're seeing is that we might be in need to change the standard and perhaps look more for something akin to negligence and not necessarily intention if we're going to be effective in our fight against algorithmic collusion. So that's from our side. Thank you so much.
Yeah, thanks, Victor. That's really interesting. So one way to think about this is that you are trying to prosecute this under an effects test rather than a purpose. You weren't setting out to do this, but this is actually the effect of what's happened. So,
yeah, exactly. If you're benefiting, especially if you're benefiting from this, it's just like you're getting a profit from what you're doing, and you're taking absolute no measures to protect competition process. Yeah. I think it's just like you're not going the standard of a reasonable person trying to prevent competition offenses.
Yeah. Interesting. Thank you very much indeed. So now we're going to call on Doris, who's going to, oops, hold on. So we're going to Doris, who's going to talk to us about some of the economics that's involved in this. You've got some slides for us?
Yes, good morning. Thank you very much for having me at this wonderful conference. Congratulations to the organizers. I'm speaking as an NGA for the German Bundeskartellamt, but I'm speaking in my capacity as an economist, and I would like to show you what the economic thoughts and the economic concepts are when we are talking about collusion of pricing algorithms. I want to have the next slide. Yes. So the core challenge is, because not everything is bad when we are talking about artificial intelligence or algorithm, the core challenge is to make a proper distinction. The pro is dynamic pricing is possible, transaction costs are going down, and we have a better match of supply and demand. The risk side is that we might have a hub-and-spoke situation where a service provider is coding a pricing algorithm that is used by different competitors. A second situation is what we call economists as predictable agents, that it is possible with the support of AI or algorithm to find out the future strategy of a competitor and include that future strategy already in your own business strategy. And the third situation is what we call a self-learning algorithm. It is a programmed pricing algorithm that is going out, meeting the other pricing algorithm in the competitive scenario, and depending on the reactions of the other pricing algorithm, their own pricing algorithm is learning and developing the pricing strategy. While the goal of every pricing algorithm, because they are coded as such, is to increase the profits. So every pricing algorithm will set a price that is profit creating for every company. So the problem, what we are facing is with the algorithm is the real-time data processing and the extreme market transparency. We were already speaking about the word tacit collusion. Tacit collusion is a difficult concept. It's not so easy to implement. And the situation is that tacit collusion is not going to happen in every market. It's just in specific market, under specific market circumstances, what I call the marginal markets. And in such a marginal market, when you add the pricing algorithm, then it's on the edge, and that market might be tipping towards an anti-competitive situation or an anti-competitive outcome. Well, in order to find out, we can borrow the diagnostics which we have developed for tacit collusion in traditional markets. First criterion is market transparency. In a traditional brick and mortar market, transparency is low. In an algorithmic digital market, transparency is very high. Frequency of interaction in traditional markets is low and slow. In the algorithmic world, it's very quick. It's almost near instantaneous. Now, from the economic perspective, the most decisive criterion is the lag in retaliation. And just to explain you some basic economics, well, not explain, it's just to structure our own thinking. A company wants to make profits. In order to make profits, the company is reducing the price. A price reduction is going to lead in an increase in demand, which leads again to an increase in sales and an increase in profit. So from the company perspective, a price reduction is always aligned with an increase in profits. And in traditional markets, a company can do so for a specific time before the other company, let's call it company B, is going to react also with a price reduction. So the whole demand is then going to company B with the lower prices. Demand is going there, profits is going there. So competition is such as a wave. It's going from company A to company B, the profit, and probably then to company C. On the bottom line, a competitive price equals marginal cost. This is the last point where a company is going to start to make loss. So the profit maximization is is the very nature of every company to be active in business. Now, this depends on what is called in economic theory the retaliation lag. So how long is the time period between the price reduction of company A and how long does it take that the other company is finding out that there's a price reduction and lowering the prices as well? Well, in traditional markets, this time period is weeks or months. But in algorithmic markets or digital markets or IE-supported markets, that is zero. So meaning it's near instantaneous. When one company is lowering the price, the other company is observing the price reduction immediately, would lower the price again, but company A did not have the possibility to gain a profit. So this is the whole problem about is this lack of retaliation, meaning every company needs to make profit, so the two companies start to collude, decide we are going to increase our price in order to make or create a profitable situation. So the retaliation lag is the most decisive criterion. Now, with respect to the sustainability of such a tacit collusion situation in a traditional market, in a tight oligopoly, it's about 2 or 3 companies. In digital markets, it's broadened. So in such a market situation, usually a tight oligopoly is considered to be 5+ companies, meaning that the problem is even larger. Now, on the next slide, you see on the left side a graph, and the graph is simply, so there needs to be one slide in every economist's presentation that is difficult to understand, so this is my slide, but the graph is showing you that every company is thinking about, I want to do a short-term profit by price reduction, and the slope of the curve is that the company is discounting the profits over the time because they are not secure. So that is why the slope of the curve is going down, and then at a specific time, at a later stage in the traditional market, company B is finding out there was a lower price, lowering the price themselves. And the hot issue and the hot potato in this algorithmic pricing is that the reality of the algorithm is a zero lag, meaning that based on sound economic principles, as soon as there are 2 pricing algorithms outside and they are programmed to make profits, they are starting to collude, and the pricing will be at the supra-competitive level, probably reaching what we call the willingness to pay level. So it will be, per definition, based on economic thought, it will be above a competitive price level. So this is the economic reality you are facing. On the next slide. So every deep learning algorithm is, because of this profit maximization theorem, it's going to reach a stable, super-competitive price level. And you as authorities, you are faced with the challenge. There is no human interaction anymore. There is no horizontal cooperation. The training of the pricing algorithm is done in-house with technical people, economists, and business people. So one option could be, and I would call this option as disproportionate, to make a mandatory transparency for every pricing algorithm. It is disproportionate because there are just a few markets with specific criteria that are the markets that should be of your concern. But maybe let's have a look first on what I call the liability gap. So I do believe that when there is human interaction and the humans decide we are going to use an algorithms, I think this is covered by traditional enforcement. I have the same belief when it comes to the hub and spoke cartels, because the hub and spoke cartels also involves a human action. So I consider this also covered by traditional enforcement. The liability gap I do observe is really when you're talking about the self-learning or deep learning algorithm. So where the coding is done in such a way and you cannot blame a company to do so to maximize the profit. The coding is done in such a way, and then because of the economic realities I was explaining, you are going to land at a super competitive price level. Now this algorithmic reality is a heavy weight, because in fact, what is the counterfactual situation? Because you cannot blame a company of doing profit. So one option could be to do nothing, so apply a laissez-faire approach and just let it go. However, I do consider a laissez-faire approach also not the best option, because there will be citizen harm. So the welfare of the citizens is going to be decreased, and that is everything competition law is about. We want to have fair markets, open markets at competitive prices, because this is important for our democracies. So laissez-faire is not an option. Well, I thought of two possible solutions. Shift in specific markets under specific market circumstances the burden of proof to the companies that they need to prove that their pricing algorithms do not produce anti-competitive effects. This line of thinking is based on what we have in EU competition law. We have Article 101 and Article 101(3, the exemption, where also the companies are doing a self-assessment. So borrowing this thinking, it could be that a self-assessment of specific companies in specific markets could be a solution. And for you as competition authorities, you cannot wait anymore for leniency applicants to come in. You need to be active. You need to become active by yourself, and why not use the tools that create the problem? So you can find, with artificial intelligence, pricing algorithms outside that are producing anti-competitive effects. So my advice as an economist is that the problem can also be part of the solution. So when pricing algorithms are increasing prices to a super competitive level, use artificial intelligence and algorithms by yourself to find them. In a company or the industry perspective is they can make sure that their pricing algorithm is not really anti-competitive. They can, when the coding is done, prevent to include competitor-sensitive, non-public information. They can exclude cheap talk or rivals signaling from the coding. They can apply a so-called sandbox approach, where the pricing algorithm is tested up front, and when the pricing algorithm is launched, they can do live audits and real-time monitoring. So I have three takeaways from the economist perspective: that not every pricing algorithm facilitates algorithmic collusion. It's just in rare situations, specific market circumstances. For competition authorities, the takeaway could be use artificial intelligence to detect harmful price algorithmic collusion. And for companies, maybe they should extend their human compliance programs also to artificial intelligence. So that would be three takeaways I have for this discussion.
Thank you very much, Doris. Really interesting stuff there, and raises a bunch of legal and enforcement questions, which and some potential solutions as well. Let me go now, please, to Diogo to talk about what's been going on in Brazil.
Thank you, John. And first of all, thank you, President Mike and the PCC for hosting this wonderful event here in Manila. Algorithmic collusion is a key concern for CAGI, and mostly when we are talking about AI-driven markets. And the interesting is that we've been discussing algorithmic collusion for many years here in ICN events, and I think now we are changing from a view that was more like science fiction to something that is becoming reality. And to illustrate that, I would like to talk about two recent cases of Brazilian competition authority that concerns with algorithmic collusion. And the first one regards a startup company in Brazil that creates a pricing algorithm-based software to give recommendations to gas stations about the pricing policy of these gas stations. And the algorithm is based both on public and private data. And of course, our concern was how they dealt with this private data that they carry from the gas stations. And what we found is that this software could be used as a hub and spoke way to do alignment, price alignment between the gas station, which is already a problematic market in Brazil regarding collusion, traditional collusion. And the main concern is regards something that Vitor and Professor Doris had said, is regards the possibility of test coordination based on this solution and this software that the gas stations were buying from another company and not need to talk to each other to do a cartel. So we started the investigation. Inducing coordinated behavior is a similar conduct to cartel in Brazil. So we started an investigation against this company, this software company, and the case was solved by a cease and desist agreement, which was very interesting to us because the Cadiz Tribunal has the word about algorithmic collusion for the first time. So we sent a clear sign that this type of use of algorithmic pricing can benefit consumers and can be efficient for the economy, but also raise concerns about competition issues. And so they have to be developed and they have to be designed with careful and with complying with the competition law. So in this case, we also carried out a study from our department, our economic studies department, that has shown us that the companies that use the tool for their pricing policies had some alignment of prices, and the companies that didn't use the tool were not aligned with that same level of prices. So the case was solved in a cease and desist agreement, so there's some financial sanction, but I think the more important sanction was a set of obligations, of compliance obligations that allow the authority to monitor how this algorithmic design is being used by the firms, and also to send this advocacy clear signal that we are careful, we are looking for this type of algorithmic collusion and algorithmic pricing. And also the lessons learned from this case is that we have to adapt our traditional tools to investigate this type of collusion. We are not talking anymore about, rooms, smoking rooms with, with some CEOs. We are talking about robots that don't need to know each other. They don't need to like each other also. But they can reach the same result as a traditional cartel. So we've been currently developing some computational models to deal with that. And just last week, we opened a new investigation regarding the airline sector, investigating the two major airlines from Brazil that we can find that they are having some price alignment and mostly in the high and the most commercial valuable routes of Brazil. So in this case, we use some time series techniques, economic techniques to test some patterns. And also we use some modeling based on complex dynamic systems to test. And all the tests pointed out that they are they have this alignment of pricing alignment in these routes. And then we also analyze the contracts between airlines, the two major airlines, and the same providers of these solutions, these algorithmic solutions and these algorithmic pricing systems. And what we find out is that these arrangements allow them to have almost real-time information from each other, which allows the two major companies to react and to reduce the uncertainty that could drive to a more competitive pricing. The airline sector in Brazil it's an oligopoly, so there's almost a concern about some kind of collusion or coordinating between these companies. And what we've seen until now, it's still the beginning of the investigation, is that this kind of tool, this algorithmic pricing tool, they are facilitating even more their coordination. So that's an important case. Both cases shows us that we need to adapt our investigative tools, and that we really must build capacity in our authorities to create these computational models that can allow us to detect these kind of patterns, because as both Vitor and Professor Doris said, it's very, I think the main challenge is how you gather evidence when there's no interaction between us.
That's really interesting. Can I just check, did I understand it's the same software company that was helping out the gas companies and the airlines?
In both cases, yeah. And in the case of the gas stations, it was the same company providing the software for the gas stations. And we discovered that because they are advising the software for all the markets.
Yeah.
And in the case of the airlines, they use almost, they use always the same companies. It's not only one company, but it's the same companies that develop this kind of algorithmic pricing. And they, basically what we saw from the contracts is that they have the same arrangements. So it's the same...
vertical arrangement.
Yeah. It's the same type of information that they share.
Very interesting indeed. And it's sort of, I mean, I don't know, just a little theme that's emerging here for me is that the sort of idea of per se offence for cartels is really difficult here, but it's heading towards a kind of a rule of reason and effects-based approach, it seems a little bit. But anyway, let's move on to Ravneet. You could talk to us about what's been going on in India. Thank you very much.
Thank you. So in India, we've been looking at algorithms for a long time, like every other country. So we have algorithms being used very frequently in digital markets, especially by the platforms, the gatekeepers, and this could be for anti-competitive practices like self-preferencing, cartelization, bid rigging, etc. But now when we are looking at cartel enforcement and algorithmic collusion, we have another layer added, which is the AI layer. And as indicated earlier also, that this AI layer has made things very different, because now the speed and scale of coordination can be much more. The accuracy is there, and the margin of errors have shrunk. And it's very easy to monitor for companies which are indulging in such conduct. It's very predictable, it's very easy to monitor. And that's where the challenges come for the competition authorities. Because now the coordinated behavior can be embedded either in the code or it's in the product design. It could be part of the default settings. It could also be part of the optimization parameters which are being put in place by the various stakeholders when they are using AI for the purpose of price coordination. So what is required then in such a scenario is that the competition authority has to have the capability to look at not only the normal WhatsApp chats and the forensic evidence, but also look at the way the coding is being done, what are the kind of outcomes which are being looked at, and what is the process which is being followed, not only what is the final outcome of it. That requires more capacity within the organizations, within the authorities, because we have so far looked at algorithms in a different way, and now we need to look at more details, the audit trails, the logs, the APIs, the code which has been put in place, and we are building expertise for that purpose. In the meanwhile, with a view to understand more about this, we had also undertaken a market study where we had studied artificial intelligence and its impact on competition. So the potential concerns were identified, and of course, we came face to face with this question that how do you fix responsibility? Because as a competition authority, it is not only our job to identify anti-competitive conduct, but also to be able to say how it is being done and who is doing it, who are the people responsible, what is the evidence, because ultimately the competition authority in India is having adjudicatory functions as well. So we would need to be able to justify in case any penalty is being imposed on any entity. And that through that market study, then we decided that let's do a very soft intervention for the time being. Let us not get into enforcement straight away, but as an intervention, we have given guidance. What we have clearly indicated through that study is that the person who is going to benefit from this facility, from this algorithm, is the one who's going to be liable for it. So that is how we are going to look at it. It's not a meeting of minds, but the vendors or the software providers, the coders, they are indulging in a B2B function. Whereas when anybody goes and uses that algorithm and derives benefit from it in a B2C transaction, that is the entity which is responsible for the collusion in case it is happening, any kind of coordination which is happening through that mechanism, through that tool or application. So as a first level, the guidance which has been given out in the study, we have an appendix attached to the market study, which is now on the website of our commission, where we have said that it is the boards and managements of these organizations which are going to be responsible. So in case you are engaging a vendor and you are also sharing data, you are having a common vendor, or you are asking for price determination in a coordinated fashion to be the outcome of that, then as a board, you will be responsible for it. So that is the first level that we are talking about, where we are saying, okay, you are aware of what you are doing, and you need to be maintaining a log of everything that is being done. So what is the compliance that you have put in place as a competition compliance requirement to ensure that whatever is being put in place is not anti-competitive? So is there a monitoring? What is your communication with the vendors? What is the kind of requirements that you are asking for? Are you aware that they could have any anti-competitive effect? That is the first level. Of course, we still have now, as everybody else is learning about it, the autonomous systems which may come into existence. That is going to be the challenge, because in case machine learning is providing outcomes which were not premeditated and which were not in line, not completely aligned with what the objectives of the organization were. So how far we can hold that very same entity responsible? I think that is going to be the new challenge which all of us are going to be facing very soon. One has started hearing about it all across the world. But for now, we are looking at AI as a tool which is being used, algorithms as a tool which is being used for increase in efficiencies, increase in competition, in consumer benefits, but being fully aware that in case there's any anti-competitive effect, then who are going to be the people responsible for it? So that is something we've started as a first level. And of course, once we come to the autonomous systems, we would have to look at how do we look at the challenges which will emerge on that front.
Thank you very much indeed. That's some interesting stuff there about the attribution of liability and, of course, whether or not the mere presence of a benefit is sufficient to make you culpable if it was accidental or not premeditated. So really interesting, thank you. Now let's go to Alvin Koh, who's going to talk about what's been going on in Singapore.
Thank you. I know we're running a bit short of time, so I'll try to go as quickly through my slides as possible. I have about 25 slides, so I'll try to finish as many as possible. No, I'm just kidding. I only have 8 slides. Okay. So let's begin without further ado. So first of all, I think it's quite clear that businesses today are increasingly making use of AI and algorithms to make pricing decisions. And the commercial availability of these Gen AI systems has really lowered the technical barriers for businesses to automate these commercial decisions, such as pricing. And I think for a lot of the micro and SMEs around the world, they're now embracing AI. And I think you can see that it's making quite a tremendous difference in terms of efficiency, in terms of the ability to reach different groups of consumers. And I think it is quite a game changer. There are also clear benefits in terms of certain areas. In terms of data processing, for example, you get real-time analysis of massive data sets for immediate market insight. I think that is something that cannot be overlooked. Agility, you get instantaneous response to supply and demand fluctuations. And of course, optimization, ultimately you have enhanced allocative and productive efficiencies across the value chain. I think that's something that the economists would value quite greatly. And these things bring clear benefits from a competition standpoint. I think the enhanced ability of AI to process and compute large volumes of data would enable companies to better respond to demand, supply fluctuations, and really enhance allocative and productive efficiencies. But of course, there are risks, and I think this panel has talked about the risks quite a fair bit. I think to start off, I would like to mention about the black box nature of Gen AI, where oftentimes you have the advice, the recommendations, and the overall intentions of such AI. They're really opaque and uninterpretable. Very difficult to understand, oftentimes to its developers, much less to its users. I think it's very difficult for us to try and figure out whether or not there is sometimes collusion. And when markets are concerned, there is increased risk of algorithmic collusion, which could be made much more difficult for competition authorities to detect. And algorithmic collusion is significantly harder to identify than traditional human-led cartels. Oftentimes, this is because of explicit communication. I think Rafnit had talked about the lack of getting evidence, such as WhatsApp chats and things like that. I think we now see that it is not so easy. You're not going to have a smoking gun between human actors, which forces us, authorities, to rethink how we go out and evidence gather. In particular, I would just like to give a shout out to younger and smaller jurisdictions like Singapore. We highlight that there are lots of challenges we face in dissecting algorithms, even if we suspect that there's going to be a case behind that. So what's happening in Singapore? At the national level, we have a clear AI strategy. Just this year, our Prime Minister Lawrence Wong himself announced that a National AI Council with a defined mandate will be set up, chaired by the Prime Minister himself. I think it's so important that the Prime Minister decided to step up and to chair the council himself. And it is a body with clear authority to set rules rather than just recommendations, a position at the highest level of government, and accountable for the outcomes of AI development across the economy. And so we at CCS, at the Competition Authority, we've embarked on an AI market study to study the potential competition and consumer issues that might arise in Singapore's AI value chain. I think perhaps uniquely for Singapore, we have a diverse AI ecosystem, which comprises both Western and Asian AI developers. And this fosters competition and resilience, providing businesses and consumers with a broader spectrum of AI innovation and solutions. To ensure that our AI market ecosystem remains vibrant and works well, our market study aims to provide clarity and guidance to Singapore businesses on potential competition risks that might arise from the use of AI in Singapore and how such risks may be preemptively mitigated. The market study also advocates pro-market AI policy making for other government agencies. So we have done a preliminary look at the market. At this point, we don't think that there is a great deal of evidence that algorithmic collusion is a significant risk in Singapore. But through the market study, we found that businesses do not yet rely heavily on third-party AI pricing applications, and there have been no reports of pricing strategies suggesting collusive behavior. So I think quite different from the experiences by other jurisdictions. I think perhaps it may be a case that we haven't quite embraced AI sufficiently, but I think we are certainly there to make sure that there isn't such collusive behavior. We're certainly watching, and I think the market study is one step ahead on this, and I expect that in future we would still be doing further market studies to ensure that the market continues to be clean, continues not to be ridden with such behavior. So zooming in very quickly on algorithmic collusion, I would propose that there are three ways to look at this. Largely explicit collusive agreements, what I would broadly call using AI to support collusive activities. Mode 2 would be hub and spoke settings. That would be largely some of the cases that we've seen, and I'll touch on these very quickly subsequently. And then I'll talk about mode 3, which is autonomous tacit collusion, which is broadly what is a very problematic area, and I think that's something that will come up in the horizon in future. So what are these algorithms that facilitate exclusive collusive agreements? They're broadly automated pricing systems that can detect and respond to pricing deviations, making explicit collusions between firms more stable. And that's broadly your traditional cartels, your human cartels, which then also want to move up the AI value chain. They want to make sure that they also embrace AI as well. And so they use AI to make the cartel a lot more stable. What are these cases? I think in recent times we've seen, we've done a quick survey of the international landscape. The UK had a case in 2016, which is the online sales of posters and frames case. And that is online, that is a case where I think the parties agreed not to undercut each other on Amazon UK. They use automated repricing software to monitor and enforce the agreement to ensure that the cartel pricing was stable. More recently, you had another case which was about energy suppliers, and they also use energy software and a consultancy company to block the ability of one supplier to target the other customers. That's broadly an anti-poaching kind of agreement. I think in that sense, my observation has been that the use of algorithms does not fundamentally alter the nature of the conduct. And these cases broadly have got many characteristics that are quite common with traditional cartels, and really the technology is being used as a tool for implementation. What's more interesting in recent years has been the hub and spoke type of cartels. agreements. And I think you see that the one that got a lot of people quite excited was the US case of RealPage. And that was a case where the participants, or rather where the businesses use RealPage's software to collect highly granular, non-public and competitively sensitive data on rents, lease agreements and concessions directly from property managers and landlords, and they use this data to generate algorithmic optimized pricing recommendations. And this software was also alleged to include multiple mechanisms that increase compliance. So really a very useful software from the point of view of the cartelists. The DOJ found that the use of such software undermined independent pricing decisions among competitors, and they allowed for the alignment of rental prices, which harmed competition. But I think late last year, in November 2025, there was a settlement on a no-fault basis with no financial penalties imposed. And as part of the settlement, RealPage's pricing algorithms will no longer be used, and they also had to remove and redesign features that limited price decreases and aligned pricing between competing users of the software. In the interest of time, I will talk about the EU case of e-Turas, but I think it's also quite exciting for many of us that the UK has recently also commenced investigations into major hotel chains, Hilton and Marriott as well. Of course, the third one, which is autonomous algorithmic tacit collusion. This is obviously the most difficult one, and I think members of this panel have also talked about this. And I think this is where algorithms autonomously choose not to compete on prices as an optimal profit maximizing strategy. And this presents a paradox as it raises the fundamental question of whether the concept of an agreement or concerted practice can even be applied to non-human actors such as algorithms. I think some have even talked about, imposing liability on the software manufacturers, but I think it remains to be seen whether or not this can actually, in fact, be done in a very practical, realistic manner. I think we note, however, that the consensus for now is that the risk of such collusion remains low, particularly in Singapore, for example. But I think we have been monitoring this space very closely, and I think as you have heard from the other members of the panel, there is quite a lot of attention and effort being spent to monitor and ensure that this area does not get out of hand. But my own view is that firms should remain responsible for foreseeable harms caused by algorithms, whether or not you are a supplier of software, whether or not you are in fact a user of the software. I think you need to have a very careful look at whether or not you are compliant with competition law. And in that sense, I think some have talked about compliance by design when it comes to AI and antitrust issues. That's certainly something that we should be thinking about quite carefully. And that brings me to my last slide, and that is our proactive mitigation efforts in this area. CCS has, in recent times, unveiled an AI markets toolkit, and that is, in fact, our effort in working together with businesses and industry, which enables AI model developers as well as AI model deployers. And they are able to self-assess whether their AI models and business practices are in compliance with the Competition Act and the Consumer Protection Fair Trading Act. Just a pitch for the team. This is open source software. I think it's easily available on our website as well. I think if you can navigate it, feel free to download it, adapt it for your own users. We hope that the toolkit can allow for businesses to self-assess their AI models that are under development. They can then look at their own business practices for potential competition and consumer protection issues. To give a sweetener to these businesses to use our AI market toolkit, we would reduce financial penalties if, for example, they eventually found to have infringed the law in some other way. So with that, thank you very much. And thank you to PCC for the kind invitation for me to take part in the ICN. Thank you.
Yeah, thank you very much indeed, Alvin. I think we'll just, I actually think we got started a little bit late, so why don't we just go on for a little bit longer, not very much longer. One of the things that's kind of lurking here, and I'd be interested in anybody's comment on it, is the extent to which current framing of laws are sufficient to get at the harms that either apparent through algorithmic collusion, as in Brazil, or potentially coming, as in your situation, Alvin. So do you recognising the need for self-assessment and the value of self-assessment, recognising the value of capacity building in agencies and all of those things, ultimately what I'm asking you is, are your own laws up to the challenge of this new form of harm?
I'll take it. Are they up to the challenge? I think that, as everyone has mentioned, it really depends on what scenario or hypo we're dealing with. So I think that, when they're using algorithms as a way, I'd like to mention, like a spreadsheet on steroids to monitor each other, is like, okay, our tools are more than enough, our legal tools are more than enough. When it comes to platforms, that's when you start to go like, maybe, and that's with the hub and spoke theory. You can go with them, and I think that at least for Mexico, you can push that theory forward, as we certainly did, and we're about to find out whether it works or not on the case that I spoke about. When it comes about self-learning algorithms communicating with each other, and there being no human element whatsoever, no agreement per se, that's where the challenges start to come up. If you'd pressure me, I think that recent legal changes in Mexico can make it a bit easier, but it's still, the law was not designed for that matter, and that's the honest reality. I think that, and the issue with law, I think it's obviously, is like you change the law and then a new situation comes up, and you just can't keep up with the changes, especially with, and as Dio was saying, this we were thinking about this as science fiction, so and it's not. So we're about to see. I think that I have no answer. I'll just say, like, ask me in a year or two, and I'll let you know.
Yeah, thank you.
Well, with respect to EU competition law, we have a distinction there, which is object or effect. So I do believe when we are speaking about this self-learning, deep learning algorithm, we are in the effect box, meaning that it's more difficult to define that this was a restriction of competition by object, but much more the effect. Is it covered currently? I would say yes. And why? Because our EU competition law also covers information exchanges. And it doesn't say that the information exchange needs to be analog or digital. So I assume that both is covered, the analog information exchange, so when the CEOs are sitting together and sharing the information, or in the digital world. What needs to be changed in EU competition law or in the application of the law is that we think that the hardcore price fixing cartel is producing average harm of 20% per year to the citizens. And when it comes to the potential harm of an information exchange cartel, currently we have in Germany a judge who is saying that the harm of an exchange of information is producing in the area of 0.5% of the revenues. So probably we need to change that perception and showing that a digital information exchange cartel can be as harmful as a hardcore price fixing cartel, and then we are fine with respect to EU competition law, I think.
Thank you very much, Doris. Do you want to
I think it's less a problem of legal framework. Maybe I think we must change in this case of collusion. We must need our theoretical framework to deal with collusion. It's not collusion like cartels, like traditional cartels. So we have to create some new structure to deal with that, not disregarding the effects of the conduct, but at the same time, we still are dealing with collusion. So we have to create something between the by object and by effects conduct. Maybe we cannot disregard of the economic analysis of these cases. So it will be not like a cartel analysis, a traditional cartel analysis.
Yeah, thank you. Ravneet, would you like to comment on this?
No, I was very clearly indicated at the beginning only that when we're looking at any kind of collusive agreements, we're looking at hub and spoke, which has been referred to specifically, then it's much easier for us to determine who's responsible and to fix responsibility. But now when you start hearing about things coming in the media, like the AI mythos, what it can do, so you not even aware as to what is going to be the implication. So the only message which is being sent out to all the banks is, please strengthen your firewall, ensure that nothing goes wrong. But what exactly it's going to, what's it going to pan out and become ultimately, we really don't know. So we are in a scenario where things are developing very fast. And it's a challenge for us, and of course we would come up to speed on that once we have greater clarity on which way things will go.
Thank you. Alvin, any comment on that?
I think we largely follow the UK and the EU case law. I think Singapore's system was designed that way. When we went down the road of implementing competition law, it was deliberate that we will also import the jurisdiction, and the jurisprudence and the case law from the UK and EU. In that sense, I also agree that the object and effect dichotomy in terms of the case law can be sufficient to impose liability where it's necessary. It's a question of evidence as well. And I think for the competition authorities, that is actually a real practical issue. Whether or not you, first of all, suspect that there is, in fact, a cartel or an unlawful agreement in that area. And even if you can, if you go in and you start downloading the algorithms, can you actually make sense of it? I think that is a very real practical issue. In that sense, I think Singapore, as well as many of the other jurisdictions, have also started to commence training teams to learn how to detect, to be able to enforce such issues, to be able to make sense of these algorithms. And I think that's a critical first step. And thereafter, I think if you look at the law, our own view is that the law today is sufficient to impose liability, but of course, you can make things easier if you have the power to amend the law. And I think at this point in time, AI is moving so fast that I think we're still waiting to see how it might settle at some point. And if that is the case, then perhaps legislative changes at that point in time might be more appropriate then.
Yeah, thank you. So it's a kind of a trial and error approach. That's helpful. We are pretty close to time. Is there anybody anyone in the audience who'd like to raise something here? Yes. Can we get a microphone over to that table, please? Or take this one forward.
Hi, thank you, Chair. Just a question to the panelists, whoever wants to answer. So one key challenge is really distinguishing between the cases where the information that's been used is public information and it's available somewhere on a website. And in the digital world, this is most, the most common case, because in that case, machine learning techniques would allow a firm to sort of monitor prices of competitors anyway. So to which extent do you think we can go beyond an approach which makes it necessary to find evidence of exchange of private information instead of public information between the parties?
Okay, so the question essentially is, does it make a difference, I guess, whether it's private or public information that's being exchanged? Anyone, we don't have to all answer. Has anyone got a take on that?
I also think it does not make a difference whether the information is public or private. I think the difference is that based on the sound economics, we know that the pricing algorithms are going to price at a super competitive level, and we have the tools to identify that this is an anti-competitive effect. For example, by looking to price variations, to the spread, to the alignment of the prices. And I would not make the distinction between private and public information. My distinction would be in the analysis of the effects.
Which brings us back to that effect space.
I was going to say the same thing, because what is happening is that when you're looking at these online intermediation services, you are able to get information on hotels, you're able to get information about airlines, and you find that the prices are very similar for the same time slot. If you want a certain slot you want to fly at in 6 to 9 a.m. or something like that, you'll find most of the airlines are having the same information. So any airline can go to the online intermediation service and see what is the price. But so you don't need to make a difference between public information and private information, what is not in the public domain. Ultimately, it is the effect. What is the effect it is happening? It's a sum total of information which is being used. It needn't necessarily be distinguished as public and non-public.
Look, thank you very much. I think we could probably easily talk about this for quite a lot longer, but I'd probably better not. I think we'd probably better stop and go to lunch. But so please join me in a warm round of applause for our panelists and their insights.
And a round of applause for our moderator, Mr. Small, as well. As with the earlier panel, may I invite you to please stand in front of the stage and have a photo opportunity. This has been the Cartel Working Group Plenary on Algorithmic Collusion and Challenges for Cartel Enforcement in the Digital Area. Let's give them a round of applause, again, for sharing best practices and giving us some insights on this particular topic. However, it is lunchtime already, and before you proceed to lunch, allow me to give you the guidelines for the breakout sessions that will happen at 1:30 p.m. so you don't get lost. To Mr. Small and our panelists, thank you very much. You may exit this stage, as it is now my pleasure and honor to guide our delegates where to go for which particular breakout session. All right. On the ground floor, there are 3 breakout sessions. At Executive Room 5, we have the competition advocacy to foster sustainability initiatives through fair competition by the Advocacy Working Group. Again, that is at Executive Room 5. Next, at Executive Rooms 7 and 9, there's corporate compliance and prevention, fostering internal detection through dynamic compliance and leniency programs of the Cartel Working Group. That was the one in charge of the panel just this morning. Then finally, at the Diplomatic Hall, there is the Heads of Agency Session 1, Cross-Policy Dialogue, reconciling competition policy with industrial policy. All of that is happening on the ground floor. Here, if you come back to the second floor, this is the Marriott Grand Ballroom, Halls C and D. We will be having the remedies involving digital markets on multi-jurisdictional transactions. This is of the Merger Working Group. Then on the third floor, we have the interplay between competition and consumer policies, integrating effectiveness and public impact of Agency Effectiveness Working Group, happening at VIP East boardroom, while in VIP West boardroom, we have the defining relevant markets in digital ecosystems of the unilateral conduct working group happening. Just in case you get lost, don't worry, we have our secretariat team to assist you. For now, I believe we just flashed those guidelines and we have maps outside, but we have a total of 6 to 7 breakout sessions happening at 1:30 p.m. So now, off to lunch, everybody. Lunch will be served at the delegation hall located at the lower ground floor. Please go back to the lobby. Proceed to the security area where you will see another set of elevators and escalators go down to basement 1. That's where lunch will be. For now, please make sure no personal items are left behind unless you're coming back to the second floor for your breakout session. Make sure no personal items are left behind. Proceed to the basement 1. Our team secretariat will be assisting you. Happy lunch, everybody, and proceed to your breakout sessions at 1:30 p.m. Bon appetit!